Thank you for this. Thank you for this great opportunity.
Prabhat. We open day 2 of our conference with a truly eminent voice in the Indian legal and intellectual landscape. It's our privilege to welcome Shri Vikramjit Banerjee, the Additional Solicitor General, Government of India. Shri Banerjee completed his BA LLB from the National Law School, Bangalore, and LLM from the University of Leicester, UK. In addition to his legal accomplishments, he has been part of the academic world, teaching at the National University of Juridical Sciences, Kolkata, and also IIM Kolkata. What makes his presence here truly spectacular and valuable is his deep and ongoing engagement with the themes of law, religion, and development. A rare and vital triad that is very, very important when we speak of Indian knowledge systems. Today, Shri Banerjee will be delivering a distinguished talk on formulating an Indic justice system. This is a subject that is of critical relevance as we look to reinterpret and realign our legal structures within the civilizational framework. Shri Banerjee. I now request our Kulapati, Dr. Nagaraj Paturi Garu, to felicitate Shri Banerjee. This is a small token of our appreciation for his contribution. I request Dr. Paturi to present him with a bouquet of flowers and a small token, a gift which includes 2 books published by INDICA. Thank you, Dr. Paturi. Shri Banerjee.
Thank you for the wonderful introduction. I don't know whether I deserve it or not, but I'll try to do justice to that introduction. Thank you, Dr. Paturi, for extending me the invite to speak on this subject, a subject which I consider after my own heart. My background, I don't know how many of you know me, is a lawyer. I work in the Supreme Court. But my interest has always been in legal academia, and specifically legal academia in relation to Indic knowledge and Indic thinking. Or what I would like to, there are various ways you can call it, and you can call it Indic, you can call it Bharatiya. I like to use the word Bharatiya, but for international audiences, when one writes or when one speaks, it's better and more understandable if one uses the word Indic. Now, I got involved, and there's a little bit of a background before I start on my presentation. I got involved from the time I was in law school on this idea of Indic thinking. And law especially, because whenever there would be some sort of a project, which we had a number of them when we studied in the law school in Bangalore, we were given things to write. And I would then look at most of the solutions, most of the laws, and people would frequently refer to a lot of American jurisprudence, a lot of British jurisprudence. I know people who refer to German jurisprudence. And I said that maybe we need to refer to some of our civilizational texts and what they said. That's a natural reaction. And so I started exploring very wonderful texts. That's for the first time I read things like, for example, the Arthashastra. I read the Shanti Parva. I read all of them at that point of time and tried to incorporate as part of the projects. Then when I went, and this is extremely crucial, when I went to study law, do my master's at the University of Leicester, and the University of Leicester was very unique, and this was this bears saying because this is before 9/11. And after 9/11, law and religion became a very hot subject, taught all over the world and taught at very many places. But when I opted to do law and religion at the University of Leicester for my master's, specializing in law and religion, I think that was the only place in the entire United Kingdom which at least taught something on law and religion. They had a master's. You could do partially specialize in law and religion. They had courses. They had a number of courses. It is through that, with my introduction to law and religion came to be. While preparing my presentation, which one finished at the end of one's course, you had to submit a thesis, an LLM thesis. My thesis was Human Rights in Bharatiya Perspective. And for that, I remember my professor, who was Professor Anthony Bradney, worked on law and religion and social studies, and great authority on that. I put his hands up. He said, Vikramjit, I'm sorry, I cannot have someone who can supervise you on this. And he referred me to, I'm sure all of you know who would have studied Indic conceptions of law and theory and Indic jurisprudence in today's age, someone called Werner Menski. Werner Menski wrote also Hindu Law and Postmodern India. Werner Menski was a professor, was a professor because he's now retired from that, at the School of Oriental African Studies at the University of London. He succeeded Professor, this name you would have definitely heard of, Duncan Derrett, who was then the professor of Indian laws, very famously in the same school. And Professor Menski is a great Sanskritist, as well as a student or a teacher of Indian laws. And it is sitting with Professor Menski, that's when a lot of these issues and a lot of these conceptions became clear to me. And I'm quoting Dr. Menski here, is besides being my guru in academia, a lot of what Professor Menski spoke about in relation to Indian jurisprudence, especially contemporary Indian jurisprudence, I think is absolutely true. And I'll take you through what I think he indicates in his books, and which I, as a lawyer, have tried to take it further and realize it's possibly absolutely bang on to the point. I'll start off with what Professor Menski's thesis is, and then I'll sort of make my presentation. Professor Menski's thesis is that the Indian judiciary is Indian, working in an Indian context, working in the Indian reality. But the laws which it has inherited are Western. So the solutions which it comes up to solve these problems are Indian ways to solve it, Indic ways to solve it. But it uses the rhetoric of the West, of global jurisprudence, what it thinks, or colonizers, depending on whatever you call Western jurisprudence, to justify its conclusions. So whether it be interpreting even something like CRPC, he has examples of interpretation of CRPC, but for this case, we will address questions of constitutional law, because that's what I think the subject of this discussion would be, absolutely the answer fits in perfectly. Because you would see that the Indian judiciary ties itself up in knots because its software is completely, because the hardware is Indian, and it is exists in Indian society, resolving Indian problems, but the way it articulates everything has to be in Western terms. So when, for example, and I'll just give it an example and before I start off on the talk, when it talks about ekam sat vipra bahuda vadanti, and which Swami Vivekananda at various times says is the keystone of the arch of understanding India, that there is one truth but the wise call it by very many names. The Supreme Court quotes it extensively, but uses the rhetoric of secularism. Everybody who studies Indian law knows that our secularism, that's the basic tenet, our secularism is completely different from Western secularism. It's completely different from the word. Now the dichotomy is, the judiciary is completely attached to that, uses that very frequently, meaning something completely different. Another use of that word, and before I, so that just to bring home the point, is the use of the word socialism. Now, if you anyway read what Indian socialism is according to the Indian judiciary, it does not say Marxism and things of that sort. It says that it uses Sarvodaya. Now, Sarvodaya, to my understanding, is a very Indic solution of problems of having daya for the, for everyone. It's a Buddhist term, effectively, and from Jains and Buddhism, saying that, good for all, sarvo, Baujan Hitacha, Baujan Sukhaya, it's that term. It's like for the benefit of everyone. The Indian Supreme Court uses that term. So, in many ways, and I'll take you through, and you'll be shocked as to how much it uses that. It's shocked as to how much those techniques are used to interpret Indian jurisprudence. Now, that is why he attributes that to, in conversations, he attributes that to hypocrisy. But I am entitled to be a little bit more kinder. I would say, I would agree with V.S. Naipaul, who said, we are a wounded civilization in many ways. So we are ourselves torn, and especially our elites are greatly torn as to whether to look like as if, between, as again Swami Vivekananda said, between the Scylla of Western civilization and the Charybdis of Indian civilization. So, that being said, now I'll come to what I will make the gist of my presentation will be on those lines. When the whole concept of having an Indic system, there are two questions which arise. Is, can you have an Indic system now? Because the questions which are put to you is, you've never had an Indic system definitely not for the last 800 years, or maybe 1,000 years. So how are you going to bring all that back? If you're going to have an Indic justice system, where does that exist? And two, what is the use of bringing back a justice system if you can't implement it on the ground? It doesn't make sense. But my proposition on that is, all that is incorrect, absolutely, because we do not, the strange thing is, India works differently, or Bharat works differently, and we like to say it, India works differently. And there is the inability of comprehension of how real India works. And according to me, and this is where I take off, according to me, the Indic justice system historically has existed at very proximately. And not only has it existed extremely proximately, and I'll give you examples of that, but also it exists right now. The system is working with you right now. It is that we are not looking for it. Because a justice system is a system for resolving disputes. It does not have to be dependent on a code of law. It has to, or a written down statute, or doesn't even have to exist on written books. Because as any one of us know, that our civilizational history, a large part of our history as well as of our laws has been unwritten, has traveled from word of mouth. So a large part of it is internalized. And there's a very interesting example. I remember this, and better than, which brought this strikingly to me. While I was in Kolkata, and there was a charity cricket match going on, and there was the Singaporean player, tournament, friend, who was a part of the cricket match, and we were discussing about India. So he said a very interesting thing. He says, if you are from an outside, Singaporean Chinese, so he says that if you are from outside India, you would think this place is a complete chaos. It's crazy. Nothing makes sense. Till you come and live in India, then everything makes sense. But you have to be insider. And that's what I am saying in most of us, because we have internalized that logic which is within us for thousands of years. We've learned it being part of the families that we are in, that we take it for granted. We use this to solve problems. And those structures exist even today. Those structures for solving problems exist today, whether the state has a very difficult time in trying to make sense of how to deal with those structures. Now, coming back to the first part, I personally think that the Indic justice system was accessible till 1947, 48, and the books are still there. All of us forget, or most of us forget who deal with the law, that before 1950, there were very many, most of India was governed by princely states. And every princely state had its own justice system. And a lot of these princely states had these justice systems which originated in Indic systems. I know for a fact, and this I'll have to pull out, I sat at a seminar where someone compiled the justice system of the princely states pre-constitution and analyzed its roots and its thinking, and were deeply Indic. And all these justice systems, I'm sure they will exist in Mysore, Gwalior, Baroda. A lot of them towards the end started adopting British law under the pressure of the British, who wanted a uniform system. A lot of them adopted maybe some parts of the Indian Penal Code. But it was never uniformly accepted. I know for a fact, and I had this discussion, this I assume is a Chatham House rules. There's a project which is presently going on in Nepal where there is an attempt to study the Narada Smriti, because their entire, before everything was universalized in Nepal, there was a time when people thought that they could formulate a justice system based on Narada Smriti, which, as everybody knows, is the last and latest Smriti based on which justice systems were constructed. Manav Dharma Shastra is Manusmriti is earlier, but as even Swami Vivekananda says, Smritis have come and they've been updated, and the last one was Narada Smriti. So it's an ongoing project, and it was implemented in the 50s. So these things exist, These books exist. It is a fact that we need access to those books. I remember, again, having this conversation, and I'm always on the lookout of that. When I went to Gwalior, I asked people, and I say this story over and over again. I went to Gwalior, and I went to speak on a topic like this. So I finished my speech, and then I asked someone, one of the eminent people at the bar who came to meet me. So I went and asked them कि आपको पता है ये कहाँ पे है? बोले हाँ है, सब लाइब्रेरी में है. Judges library में होगा या बाल library में होगा. तो I was very keen since he was part of that project, this seminar sort of a thing. So I said, जरूर आपको पता, मगर कोई पढ़ता नहीं है, किसी को पता नहीं उसमें क्या है. So I'm saying that if you are serious about this, on one hand we are talking about bringing jurisprudence which existed in the old texts back and making it relevant today. I am saying that it did not disappear, and you need to have indicators and how it developed along the way, because it did develop, because it did survive, and people will tell you that it didn't, it disappeared for 800, 1,000 years. My understanding is, even structurally, even state-wise, as part of the state, even though I'll come to the latter part where I'm saying socially, because our law was largely social, so socially it didn't disappear at all. But even in terms of the state, it did not disappear. It continued. But it's only that in our lived memory we seem to have forgotten it. And it's in the 50s, so it's barely 70 years back. We've all had internalized the rhetoric that we didn't have a history till the Constitution was formed. That's not actually true. I think my mother was born before the Constitution was formed. My father was born before the Constitution was formed. So anyone who tells you that we were all created after the Constitution was formed is, for the want of a better word, is being slightly economical with the truth. But that's a fact. There is another aspect which I just want to flag, since we are going on chain of thought before I sort of address the other parts of it. There is another place, if we are looking for systems, which we should look for. And this is something which is going to be controversial, because there's a little bit of resistance to it. I think we should look for these institutions in Buddhist thought, because till today, in Southeast Asia, systems were run, are run in some places, based on conceptions which are Indic in nature. But of course, which have a different orientation being Buddhist. We accepted, as Swamiji again says, we accepted Buddha as God. So, I don't think this is not a part of our structural understanding of the world, and for thousands of years it was a product of our thinking of how we perceive the world. So we need to understand conceptions of law and jurisprudence maybe in Tibetan thinking, in Burmese thinking, in Thai thinking, in Cambodia, maybe even in Japan. Because you cannot understand Indic thinking, according to me, without having also understanding Buddhist thinking. Because after all, Buddha is the avatar of Vishnu. So anyone who tries to put Sanatana in a different bracket and Buddhist in a different bracket, I don't think is again being completely correct. So we need to, I would even say this, and I said this at that IIT presentation which I made, I said that maybe you even have to look at way Indonesia, which converted into Islam, dealt with certain issues. Because even though it converted into Islam, but because it wasn't a complete wipeout of its past, because of its very specific historical background of its conversion, retained parts of Indic thinking. And how to deal, very interesting conceptions of how to deal with diversity, how Islam deals with diversity, how Islam should deal with diversity. These are questions which Indonesia has dealt in a very interesting manner. So we need to explore those issues. And it's important that we also look for inspiration not only in India, but also in the wider Indic world, Bharatiya world, whatever, or greater Indian world, whichever way one would like to talk about it. Now comes to what are the structures which sort of exist in Indic society. What are the Indic structures which still exist? Now to go into that background, it's very interesting for us to understand what is dharma, which is the basis of an Indic justice system. Dharma is, this all of you know, and I'm carrying coal to Newcastle to say this, is dharma comes from the word dhri. Dhri means something which holds the world together. And dharma is both personal and universal. It is imminent and immanent. And it is what is famously called in Mahabharata, dharma is shukshma. Very difficult to figure out what dharma is. I would say dharma is always contextual. So our justice system is fundamentally different. And what is the object? Let's contextualize before I go into that. So dharma is contextual. But so people around you, so your dharma may be different depending on different situation, depending on who you are, depending on where you are. So unlike a Western understanding of jurisprudence, which is basically based on a code or a statute, which is uniform, which is in many ways very clear, saying that if you violate this, you suffer these consequences, these are your exceptions. Dharma is in many ways much more fluid, structurally fluid. And it is in many ways unwritten because there are multiplicity of dharmas. As an aside, as an anecdote, I don't know how many of you know, when the British first came to India and they started to resolve Indian problems, their judges would sit with Indian Maulavis and Indian Pandits to assist them to come to decisions. Everybody knows this. It had to be discarded. Do you know why it had to be discarded? Was they sort of thought that the Pandits who were sitting with them completely made up their jurisprudence depending on every situation. They would get their justifications for everything. So every situation was decided differently. There was no uniformity of advice. The reason being, according to me, is because both perceived justice differently. Or I'm not saying justice may be the same, but how to arrive at that justice was arrived differently. While the Indian Pandits saw it in the way of a dharmic way to do it, which is like everything is contextual, the British and the West look at it in an objective way to do it. Like you are a statute, this is what you're violating of, these are the exceptions, you don't fall into that, you're punished. This is the punishment, maximum punishment, minimum punishment. So the British then try to uniformalize it. So therefore, then they go into this entire process of coming up with the codes. Because then the British realized that you can't govern India in its own terms because you don't understand that, because there was actually an incomprehension of each other. Because the Pandits never got the judges who were sitting with them, and the judges never got the Pandits. So they said, now how do we solve it? We solve it by having statutory laws. We take common law, we make them into statutes, codify them, and apply them on India. They did it not only, they did it for the penal code, which they were in charge of right from the very beginning of their administration. They did it for your family law. So today the Muslim law which you have is Anglo-Mohammedan law. They made substantial changes. That is when the first Hindu translations of the Manusmriti happens. Because they start treating Manusmriti as a code. They said, now you will be governed in Manusmriti like a code. Because that is what they are used to. But we've always treated any Smriti effectively to be modified by custom. We've treated a Smriti, according to my understanding, is always been treated like a manual. A manual is a sort of compendium of customs and compendiums of dharma, what it should be. It's an indicator. It's like the way you sing Indian music. And I've been told, I'm not a great great knowledgeable person in Indian music, but while in Western music notation is clear, this is how you're going to play it, I've been told Indian music restricts, this is what you can't do, this is what you can do. So dharma is to be interpreted on those lines. This is what you should do. This is what ideally is done. While, they start interpreting it, translate it. There was a huge movement of translating Manusmriti. The Smritis are translated in those terms. And the Smritis are translated, that's when they realize the entire history of India is very, very old. Because they want to translate the Smritis for basically administering the country. So all this William Jones happens, etc., Asiatic society. Because the objective is to administer the society. And when you want to administer, you have to know the laws. And you see the laws and you can't decide as to how this happens. So then you say, okay, so this must be a code. You translate it and you put it into writing. And so that's when the entire issue starts happening. I think if you are talking about Indic justice system, you have to understand this. The second is the conception of punishment or danda. Now the use of danda in terms of Indic jurisprudence is that if you fail in your dharma, danda is a god. Danda is imposed upon you so that you can follow dharma. It is not a punishment for what you've done. It is a method to get you to follow your dharma. Now, this conception, I don't know how many of you know, dharma, danda was treated like a god because it was to help you to follow dharma. Now, British again had extremely different conceptions. It was almost, the biggest problem with the Indian state, which I feel today, is the basis of the Indian state is based on certain conceptions which are misconceptions in themselves. And that's the same problem with Indian law. The British never understood, and I don't blame them. If you come here, suddenly and you are in charge of this very vast empire with a very old history, they didn't understand India. They could not. So they tried to approximate to what they did understand. And so they came up with these conceptions. But the most essential part of it is, and this is to be understood, that most of our understanding is social in nature. Our sanctions were social in nature. There are, if you know Indic history of law and jurisprudence, I think the first sort of interference in punishment in a regular manner is what the Arthashastra says during the time of the Mauryans, which is a great bureaucratic state, what is the Kantaka Sodhana office is created. And that is when, remover of thorns, Kantak Sodhana, remover of thorns, I think that's the English translation of it, that is when it was first created. So our implementation of our dispute resolution has largely been social, by social sanction. You read a Dharma-shastra, most of it is by social sanction. The Arthashastra of Colonial, which comes from more or less approximately from the time of the Mauryans, talk about an invasive state. But you look at, again, Shanti Parva, most of it is social. It's only in extreme cases does the king interfere. And that remains the truth today. And that is what I was saying. Our incomprehension of our own justice system is because it exists right under our noses. It exists right under our noses. You go out of this city 50 kilometers, 100 kilometers. You will have panchayats solving huge issues. They solve issues from divorce to even murder and crimes. They solve everything. I know in Bengal they have a system, used to have a system called Shalishi. It's looked down upon. The urban people look down upon that. But I can assure you, most of property disputes, even in supposedly a westernized, enlightened state like Bengal, which were very close to the British project, because the British project starts off in Calcutta, still remains, people still resolve their property disputes, I know for a fact, their matrimonial disputes, I know for a fact. No one goes to courts. They solve it through Shalishi, Panchayat, you can call it for the short word. And they solve it on those principles, those customary principles which exist. But the Indian state does not know what to do with this. Because for a want of a better word, and I'm going to make a controversial statement again, the Indian state to large amounts of people in India is still a foreign entity. Whether you like it, whether you do not like it. The Indian state, especially the Indian judicial system, is clearly a foreign entity. Except for the cities where, we have friends who are lawyers and who take cases up and they'll go to court if they're friends of ours for free but no one trusts lawyers. My father, who was from a different generation, said a very interesting thing. He said, he told me in Bangla, Romi Ranjan is here, so would possibly appreciate that, which says, Baghe chule 18 gha, ukile chule mrityu. If a tiger attacks you, then, you can get poisoned by that. And it used to be terrible because a tiger attack is not only about the tiger eating you or harming you, but the tiger's claws are poisonous and people would die of septicemia from the attack of the tiger. So, and a tiger attack is not only about the claws, about the teeth, but it's also about the infection which you get from it. So, if you get attacked by a tiger, you suffer like mad, but if you get, if you fall into the hands of a lawyer, then you will not survive. And that seems to be still a fact in large parts of India. And you see how the Indian state deals with it. When the Indian state, that's the entire conception of how does it deal with conceptions of panchayat. The Indian state tries to appropriate panchayat. So it does it is conflicted because it knows that this is an issue structurally. So it tries to adopt what is called a good panchayat and bad panchayat. Good panchayat are those panchayat whom it can adopt and whom, it brings into the constitution, makes changes in the constitution and brings it as part of themselves. And even some nyaya panchayat, it said, gives them some power to solve problems. So it makes them a good panchayat. And it comes down very hard on what it considered bad panchayat. But it's a bad panchayat who takes most of the decisions. If you look at liberal rhetoric, they are not against panchayat, but they are against institutions which solve genuine problems outside the rubric of the state. And that is what is called the bad panchayats, Khat panchayat et al., Salishi et al. I am not saying that's a perfect institution. Please don't get me. I'm not glorifying panchayats. Every institution has its problems. You know, I've been Advocate General of Nagaland. And I'll tell you, it's possible to have a working system based on this. Nagaland has, because of its history, has managed to keep this sort of village-based dispute resolution system intact. It exists. It works. The Indian state is continuously trying to impose the Indian judicial system on top of it. I remember having this discussion as the Advocate General. I was speaking to the presiding judge of one of the bordering districts of between India and Burma. And I went and spoke to her and I said, how much work do you have? You know, what is your work schedule? What else can you speak about with a district judge and from a strange district and you're meeting them in a conference? He said, sir, not much work. He said, what do you mean not much work? I go there, I have no work, I come back. He said, what do you mean that you don't have any work? He said, sir, no one comes to court. Everything is resolved in dispute resolutions. But the Indian state, I know for a fact there are judgments of the Guwahati High Court which says, no, you have to have a district magistrate and you have to have a separation of the executive, you have to have district judges in place. And we are all very proud that we are extending this to every corner, Indian judicial system of every corner. Genuinely. But I am not going to glorify and say that system is perfect on the other side, because you as an Advocate General also see the misuses of those systems. I'll tell you that. And I'll tell you how it reflects on broadly other issues. And because no system is perfect, the two major issues with that sort of a justice system which we've had in India is it tends to favor dominant groups. So in case you're thinking about structuring it, this is something you have to take into account. And it tends to disfavor women. I've seen this happening. In Nagaland, I don't know how many of you know, that the government fell because there was a reservation granted to women in urban local bodies, which is a constitutional mandate. There was a resolution, the state passed a law, but when it tried to conduct elections, the government fell. People agitated on the streets, and they were like some of the most supposedly progressive parts of the Naga society. So I know for a fact that this discrimination exists. There are issues with that. So this is something which we'll also have to take into account. And when we also, another aspect of it, and even on property laws, now Nagaland has, and I'm sure in India, all of us talk about, we didn't have a conception of private property. We had conceptions of property held our conception of property is very different. I don't know how many of you know that. We don't have ownership of property, we have something called swatta. Swatta means everybody has a different claim on the same property. So it's like, I'll illustrate it so you understand, it's like operating a computer, and which is true, that's how actually ownership happens. It's like when you have a computer. The laptop is yours, but Microsoft actually owns the software, and Intel possibly owns the chip. So everybody has different ownership, everybody has different grades of ownership in that entire product. And maybe all property belongs to the king. So you have gradations of property. So our conceptions of property is different. Our properties are held in joint. But I've also seen this, that in Nagaland, because properties are jointly held and recognition in customary law of properties being jointly held, development comes at a very slow pace. So I know for a fact that for a very long period of time, when you want to expand roads, when you want to build hospitals, when you want to build schools, that's an issue. Because if properties are held in common and you recognize that, whether held by tribes, etc., that becomes a problem. How do you solve it? That is on the structural issue. Now on the conceptual issue, I think conceptually it exists today. And I'll give you an illustration of how the Indian judiciary has dealt with Indian problems, and I'll take you right through some of the provisions of the Indian Constitution, and has dealt with it in a completely Indic manner, in a way that you'll understand very clearly. The first thing I started with in the preamble, one is socialism. Secularism I spoke about. Secularism is Sarva Dharma Samabhav. It's not Western secularism, but it's still secularism. Socialism is Sarvodaya. It is not socialism, but it is still socialism. Now, a very interesting thing is the predominant value, if you look at even the preamble of India, and this is something which strikes me, is the conception of justice. Like when the American preamble to the American Constitution talks about liberty. That's the most important part of the American preamble. In France, it's equality. In Britain, it may be parliamentary sovereignty. In India, it is justice. You look at the preamble, it says justice, social, economic, we guarantee to people justice, economic and social. It strikes me, and this is what is very important for us to notice, the only approximate translation of the word justice in Indic constitutional law is the word dharma. So in many ways, if you look at even the Constituent Assembly debates and you see how the Constitution was framed, because we were Indians, even though there's a wonderful word, I think I was reading a few days back, Lord Mountbatten interview to Dominic Lapierre before he's leaving, he said that most of the Congress leaders were lawyers, and if they didn't know, they knew Blackstone and Ivor Jennings inside out. Ivor Jennings is this great constitutional lawyer. They would have all read Ivor Jennings inside out. So though they came in with common law, British common law learning, but they were actually Indian. So their westernization, according to me, irrespective of how we like to attribute it to them, was thin, very skin deep. So they were not Blackstone, they did not come from England anywhere. So in their mind, what was continuously playing was Indian problems and Indian solutions and Indic issues. But they had to frame it in this, and that goes to the heart of the contradiction. The other example is, you take a look at Article 19. Article 19 is your freedom of speech and expression. I don't think there's any provision in any constitution which has the right or restriction on freedom of speech built into your freedom of speech. It is built into it, it's baked into it. Unlike any place, any other place. The reason is this, because if you know Arthashastra, which says that you should never speak something which is unpalatable. That's the basis of your freedom of speech. In America, it's like, American freedom of speech is like, I say something rude, you say something rude, and as long as it doesn't create a fight, that's fine. And as you all say, that rhetoric, if you don't like me, write a book. But our conception of freedom of speech is you never say something which is unpalatable. So our freedom of speech, everything, and the right of the state to restrict everything, is what we call reasonable restrictions being baked into it, whether freedom of speech, freedom of association, is extremely an Indic point of view. Because it's a conception of self-restraint. The Indic conception of the world is self-restraint. You have unlimited rights, or you can do whatever you want to, but you have to restrain yourself along with it. That's a response. It's sort of baked into the exercise of that right. Now that's Article 19. The Indian conception of Article 14 is also extremely different from anywhere else. In the Article 14 in India, you have the reservation of other backward classes. It doesn't exist anywhere else. And though, I don't know how many of you know the law, though supposedly it comes, classes means caste, according to us comes with Indra Sawhney after the Mandal Commission judgment. And the Supreme Court, that's what I said, sort of equated class and caste together. And I was always of the view that the Supreme Court did it in the 1990s. Then few days back, one of my juniors took out a judgment of the 1950s and 60s, late 50s, early 60s, which said the same thing, equated, it was understood from the very beginning that class and caste would coincide. So this is again one of those interesting conversations which goes on in the Indian Constitution, where you say other backward classes, but you actually mean other backward castes, because you had to frame it in a Western term so that the West, it would be acceptable as the Constitution of the West. But you were dealing with Indian problems. So you realize from the very beginning that you had to treat equals as equals, unequals as unequals. And that jati was a factor in it. Caste, again, is an approximate word of the word jati. Caste is not jati, but you were trying to use and solve the issue of discrimination based on jati-based discrimination. And what is the jati-based discrimination? I'll just illustrate a very interesting thing to you. It says what is the jati-based discrimination is that socially and educationally backward people were to be given the benefit so that they can come out of their social and economic backwardness. That's the criteria in the Constitution. You look at what Swami Vivekananda said in 1998 about what is the duty of the upper castes in relation to the lower castes. Exactly the same thing to the T. Either you can say Swamiji was prescient, or you can say that must have been the thinking of the people. That they knew that this is the solution to the issue. And it was only that it was being, the question is how do you articulate it constitutionally? You were framing a new constitution. The other is Article 21. I don't know how many of you know Article Right to Life. Article Right to Life is extremely unique in India, because in India it's framed as everybody should not be arrested, and should not be arrested except with following procedure established by law. That's what it says. We've interpreted it as due procedure. We have interpreted that provision to mean right to life means not to live in mere animal existence. That means everything from a right to a road, to right to school, to right to education, to right to clean water, everything, right to environment, everything comes under right to life. This is a completely Indic conception of what life is. And there is no way in Europe anywhere or America anywhere you will be able to even justify this conception of a right to life. People are shocked that this can happen. But again, you had to do this because Indian conception of right to life is very different. The Indian judiciary, when it faced the problem of, traced everything, didn't trace it from other places, traced it from right to life. Because this is how the Indic conception of right to life is. This was what was in the hardware of those judges who were deciding the problem, except they had to articulate it in Western terms. So you had to go through Hoffeldian analysis, and you had to go through life is not mere animal existence, and you had to bring in everywhere, but it is to justify your Indian solution to the problem. Article 25. How many of you, I'm sure you all know, Article 25 itself tries to define what a Hindu is in Article 25, sort of defines it very widely, and recognizes for a fact there has to be, temples have to be open up to everyone. But most interestingly is the conception of Article 26 of the Constitution. Article 26 of the Constitution, interpreted a number of times by the Supreme Court, is this, that even a small subsect, effectively, I'm putting a shorthand, there's a lot of law to it, even a small subsect has a right to define its rituals. That was the entire basis of the Sabrimala judgment. That was the argument. That's absolutely true. That's an extremely Indic thing. I don't think you look at American jurisprudence, no one will ever recognize that. Because that again goes back to the old Swamiji's Sarvadharma Samabhava, Ekam Sat Vipra Bahuda Vadanti, not Sarvadharma Samabhava, but Ekam Sat Bahuda Vipravauda Vadanti line, that everybody who has their own rituals, you will have to accept it and live with it. You cannot have an uniform imposition of rituals. You've accepted that. You accepted Article 32. Article 32 is everybody has a right to approach the Supreme Court. That's the right. How has the Indian Supreme Court approached it? Saying that whoever, does not matter, can write on a postcard in jail, not lawyer, does not have to carry a lawyer, can write random things, and the Supreme Court can take it up and use that as a public interest litigation. Because it's an old conception that everybody has a right to access the king for justice. So it's absolutely, you look at it, and I can take you through criminal law also. I can take you through how you interpreted murder. Constitutional law aside, I can take you how you interpreted murder. Or punishment for murder. Minimum, maximum sentencing. And the fact that there's always, and anyone in Supreme Court knows, that always when it comes to punishment, the court will apply its mind as to approximately dharma, what he should have done under the circumstances. So unlike the West, where the imposition is, of course you have qualifications. In case you don't fit on these exceptions, you fall here. In an Indian courtroom, it's always like, what were the circumstances? That's on punishment. That is on murder. I'll take you on conceptions of murder. I'll take you on conception of theft. I'll take you conception of, payment of, alimony. So you always had Indic problems and you are, and Indic solutions to those problems, but you've used Western rhetoric to justify them. Now, that being said, so conceptually you are actually running an Indic jurisprudence. But you don't want to call it. Because if you call it, then you're communal. And I can, in many ways, I have had this huge problem. I had this discussion with some of the biggest professors. And I have faced it myself. If you want to write on this stuff, you will not get published. Even today. Because people are afraid that if they publish it, and big publishers are afraid that if they publish it, it will not be accepted, it will be construed as communal. And they will try to balance it with getting some liberal to publish their article. Saying that, okay, we'll publish yours, but I'll have to get someone else to balance this article. We'll put of them together, as if you're an extremist arguing a point of view. But it's not true, it's true, you look at it. So, what is the solution to all this? I'm saying that structural solution, I said that we need to study more. Biggest problem of our side is there's not enough work and studies which is going on. There are a lot of political rhetoric, which is fine, which is good. There are a lot of social rhetoric, which is fine, which is good. But I don't take that seriously because structures are not built on rhetoric, structures are built on hard studying, and structures are built on knowledge, structures are built on accumulating examples and figures and figuring out how things work. So we need hard work. It requires hard work. It requires good researchers, good students, good people to write it down. The British, irrespective of whatever you call them, irrespective of whatever you talk about them, really studied India. And I would say after the 70s, when the last sort of British people died out, it's only in the last 4 years when I see some sort of an output. For 60 years, Indic learning of Indic things actually, in very many cases, nearly disappeared from India. I'm sure there are exceptions to it, so don't take it as a generalization. So it only existed in London and University of Chicago and outside India. So today, when you want to bring back that knowledge into structural stuff, you are completely at a loss because you don't know who the relevant people are. So you have to go around asking people, "Mujhe list de do, mujhe list de do." I don't think that would have happened in a generation before us. I don't think that would have happened in my father's generation. Everybody knew Sanskrit. Everybody in my father's generation studied Sanskrit. They knew Sanskrit. They were rooted to the lecture. They were judges who knew Sanskrit. I know my father's generation, some of the biggest judges, they knew Sanskrit. They were Sanskritists in my generation. How many of them? No one. So that's an issue. We have to reconnect with Sanskrit, Prakrit. And I'm saying not only Sanskrit. I don't want to sound exclusivist because I think Buddhist thought is an extremely important area which we should also go into, and therefore you also need to know Prakrit. But you need to know this. And you need to incorporate it into your thinking, which needs a lot of academic work, which needs a lot of students, which needs study. And one of the biggest tools of colonization in India by the British was this study which they put in. Framing of laws, framing of criminal laws, framing of social laws. They did put that into it. Extensive studying. You look at the amount of translations which happened. Themselves, some they got somebody else to do it, but it was sponsored by the British. We need to do that kind of work, great thing which is happening here. But I think more needs to be done. I think this is great work, but it's not adequate. And we need to do that on law. We need to redo portions of our conceptions of thinking. That's one. Second, and which I think is also extremely important, is we need judges who are attuned to this. Judges who understand. There are very few of them who do. I know a handful of them. Because as lawyers, you tend to be structurally westernized. Because our legal education system is extremely westernized. And what I am telling you today is absolute, which according to me is the truth. But I dare not say it. Even as, someone like me has to be pretend westernized. But you have to be pretend westernized, otherwise you will not. The profession demands it. So you'll have to do that. So we need good judges who are knowledgeable and forward-looking. There is a tendency amongst judges to treat Indian jurisprudence as a thing of the past. It's a wonderful idea. We need to study more about it. It happened long time back, and it's great. But I don't see that being used to decide judgments. I don't also see what we also require is researchers who are able to conceptualize today's contemporary problems, let's say IT, or information technology solutions, or contractual solutions, or biotechnology solutions, or criminal law from an Indic point of view. If it's only about this wonderful sort of great esoteric knowledge of the past and history, then there's a place for it, but it's not to be taken seriously. I'm not too interested in it. But the objective would be, and I'm sorry, I'm quoting him like 30,000 times so much, is what Swamiji says. And Swamiji means Swami Vivekananda, according to me, says that you have to keep your culture intact, but you have to be relevant for today. And I think that for our justice system, I don't think that it's a Herculean task, because whether we like it or not, we have been doing the same things. Except that it requires explicit recognition, except that it requires our people to work on it. And once we have enough academic material, people will switch over to that. Because it's not that they're doing anything different, if you understand what I'm saying. It's not that their judges are doing anything different. They're solving the same issues, using the same logic, but they're using Western terms for it. So if you can bring this to them, but that requires a lot of hard work. Most lawyers, if they're successful lawyers, eventually end up making lots of money and moving out of this. I started off as greatly interested in all this. and see where I ended up. And then you don't have time. You may want to. These are wonderful places to make all these presentations, but you just don't have enough time. There are other people whom I know also who've done the same journey. But you need to make it viable and you need to work on it. And this is a wonderful place for me to say it because I know this organization has been working on that. And I wish it all the best. And thank you for inviting me. I can take questions. Am I? Questions?
It's a very small question, but it's really pertinent. Can I? Thank you so much. It was such a wonderful presentation, and it really opened my eyes because I'm so far away from the justice system. There's one question it's like just flashed into my mind because when you talked of human rights and being interpreted in the Indian way, I wonder if you could lead us somewhere to child rights being interpreted in the Indian way, because there are a lot of child rights which I'm with Save the Children, and I don't agree with them because they were formed in England, and there are so many detrimental to our children's growth and education. So is there something like that?
It's complicated. Rights is a very complicated area. Okay. Because there's a wonderful writer, and I'm sure if I had to, let me answer your question first, then I'll answer what I want to say. I'm sure if you look at it in terms of dharma, in terms of obligations, there would be, you have to look after children, it's very clear. I was reading there is a duty to ensure protection of children, and that's a very, very, it's as old as anything. There is a duty of you as a householder to ensure that protection. And in case you fail, as I'm saying, you can obviously, it's the object of the state to ensure that you follow your dharma, and the danda can be imposed to that extent. So I think that's one issue as to children, and I think there are whole loads of descriptions on, every child has to be protected, and what is the duty of a parent towards their children, and what duty does one owe for the society owes to children. That being said, the other part of the question which is inherent, which you are flagging, is the question of rights. The question of rights is a very complicated issue because it does not exist in Indian thought. There is a very famous article which is the basis of all conceptions of cultural relativism in law, called Is the Notion of Human Rights a Western Concept? Written by Raimundo Panikkar. I don't know how many of you know about Raimundo Panikkar, who has a very interesting history which I will not go into at the present moment. Raimundo Panikkar, Is the Notion of Human Rights a Western Concept? There is also some Buddhist writing on the fact which says why the Buddha has no rights. And then I think that's by Junger, Junger, who wrote about why the Buddha has no rights. And third, if you Alistair McIntyre, who's this great Western philosopher, is of the view, he has a book called After Virtue, in which virtue, and in which he says till the 1900s the Japanese did not have a word for rights in their language. And I think that's true for India. We approximately use adhikar, haq. Well, come on, it's never existed. Adhikar is not right. But is it possible to have a jurisprudence, independence? We today think that you cannot have a jurisprudence without a right structure. That's a given. But I'm of the view that you could have that. Your whole intention is to protect the child. You can do it whether you go through a rights-based rhetoric or a rights-based structure or a dharma or an alternative to rights-based structure. I think that's possible. I think we do that in any case. If you look at the jurisprudence of the Supreme Court, we do that in any case. Our logic again is Indian, but our rhetoric is rights-based. That is because if you're not rights-based enough, you tend to be not progressive, backward, and possibly communal.
Thanks. That was great. Thank you.
I came here just to share with the a group of learned scholars here that we have a Center for Jurisprudence Studies as part of INDICA. That was established by Advocate Narasimhaji, who was practicing in Supreme Court. Now he is one of the justices of Supreme Court. I was mentioning that to Banerjee ji also. And now there is a course on Hindu jurisprudence started at Banaras Hindu University by Professor Brajesh Swami. He gave the curriculum and it is running there from Banaras Hindu University. And there are developments that are occurring towards the development of jurisprudence studies. Banerjee ji was mentioning research. Center for Jurisprudence Studies at INDICA has got a very intense research group. We started with the study of Evidence Act. We formed a group of 3 Nyaya scholars, 3 law professors of Nagpur Law University, and 3 advocates practicing in Nagpur. And all these 9 were intensely studying Evidence Act provisions from a Nyaya perspective. So similarly, we have many other research projects under Center for Jurisprudence Studies. I wanted to share this information with you so that those of you who are interested in this would join. And now we have a hope in Banerjee ji that this center now has a very big support. I asked him to join us and he agreed to join our research at Center for Jurisprudence Studies. Thank you so much, sir.
Thank you so much, Shri Banerjee. That was very illuminating and it was very reassuring to know that people from that side realize that common people think that it's better to be in the clutches of a tiger than in the clutches of a lawyer. But I'm hoping that with such understanding and sensitivity, things will look brighter for us. Just to add to what Nagaraj Paturi Garu said, for the beginners here, we are offering a course on ancient Indian law, so feel free to join us. It's by a young upcoming academic from Orissa. So feel free to look us up on indica.courses, and those of you who feel inspired, please feel free to join us. Thank you once again, Shri Banerjee. Thank you very much. We appreciate your participation and presence here today.